Bob Moore. I'm the director of the Peace Action Education Fund it's the educational arm of the Coalition for Peace Action. And so I just wanted to kind of mention that relationship because Congressman Holt, Dr. Holt, had mentioned both names last night, so we're pretty much the two arms of one and the same entity. We are the facilitators of this conference. We're honored to be doing that. I would now like to call on Jim Winkler, the General Secretary of the National Council of Churches, who will be moderating this morning's session.
Morning, grace and peace to all of you. It's wonderful to be here. You know, 20 or 30 years ago when I came to conferences like this, I would walk in and say, there sure are a lot of old white guys here. Now I look around and say, oh, these are my people. And so I also thank you, those of you who don't fit in that category, for being here and adding some diversity to our group. This morning's panel is going to focus on legal and policy issues, and we have three wonderful speakers, but we're first going to be hearing from Peter Lumsdaine, who was scheduled to be on the panel last night. He is a former U.S. Department of Energy researcher and has worked on the staff of cutting-edge nonprofits like Global Exchange and Silicon Valley's Interfaith Peace Coalition. Work that has taken him from lecture halls, missile bases, and jails across the United States to the war zones of Mexico, the Philippines, and occupied Iraq. He is a Mennonite and founder of ARROS, the Alliance to Resist Robotic Warfare and Society. Peter, we welcome you.
Thank you. Good morning. I appreciate the opportunity to speak with you now for a very few minutes this morning as we begin a long day of discussion and discernment. I see my own role here as pushing the boundaries of this conference in a constructive and necessary way. As the actor playing Martin Luther King in the recent film Selma declares, we cannot yet see the full picture, and that picture needs to be painted, that we may more clearly perceive the reality we all face. We live in an age of electronic technological idolatry. The ancient prophet Habakkuk, honored by each Abrahamic religion, proclaimed, "Of what use is an idol once its maker has shaped it? A cast image, a teacher of lies, for its maker trusts in what they have made." Sisters and brothers, the war drones we read about, the predators and reapers in all their grim reality, are actually only the tip of a largely hidden and rapidly approaching iceberg. And that iceberg is not a new issue. It is not one more issue among many. It is not, in reality, an issue at all. It is rather a new era in history, a new era in human and planetary history, which, if we allow current trends to continue, will profoundly and grievously affect every issue we care about. From global employment, workers' rights, and economic justice, to the nature of war, the possibility of peacemaking, and the survival of liberty. From the ecological integrity of God's natural creation to our very understanding of human experience, community, and relationships, our very understanding of what it means to be alive. So I want to very quickly sketch out two particular points. Number one, just a hint about more and more autonomous drones in a fast approaching age of robotic warfare and social control. What the prophetic novelist John Brunner once called that strange country to which we are all being deported, the future. And second, the special opportunity and challenge for people of faith to confront this escalating crisis in human history before it is too late. Very briefly, drones and all other robots are driven by AI, by artificial intelligence systems without which they would crash. And as AI is rapidly advancing, drones like Northrop Grumman's X-47B pilotless bomber have already accomplished the Top Gun maneuver of aircraft carrier landings at sea without human involvement, as they're readied for fully autonomous strike missions. British Aerospace, the Taranis intercontinental bomber, SGT, Samsung, company after company across the multinational spectrum is developing these autonomous weapons. But the trend line is actually towards miniaturized drone clusters operating as independent yet self-coordinated groups of artificial organisms, swarms that will seek and destroy like electronic army ants or metallic killer bees. Last night we heard that the Pentagon's drone fleet expanded from 60 to 7,000 in less than a decade, though most of those drones, over 90%, are unarmed. So unarmed means peaceful. It does not. The majority of military drones from the deserts of Iraq to the jungles of Colombia are surveillance and targeting drones, like the Boeing Scan Eagle made in my region along the iconic Columbia River, where we held a milestone conference challenging robotic warfare and social control with 125 people from churches and vets groups about 5 years ago. No, the Scan Eagles and RQ-11s and RQ-7 Shadows and other unarmed drones work like telescopic sights on sniper rifles, guiding the Predators, Reapers, piloted F-15 strike jets, helicopter gunships, and special forces hit teams to their targets. But according to military experts like Dr. P.W. Singer at Brookings, the proliferation of military ground robots has moved even faster than drones. As the Pentagon's drone fleet expanded from 60 to 7,000 in the 21st century's first decade, the US inventory of military robots on the ground went from 0 to 12,000. While lethally armed ground robots aren't yet sent overtly into combat, they've shown amazing and terrifying capabilities, putting us, I predict, just one war away from their operational deployment, for instance, in the looming conflict with Iran. That's why Dr. Denise Garcia's article, The Case Against Killer Robots, illustrated with a photo from James Cameron's Terminator films, was published last May in the US intellectual establishment's most prestigious international policy journal, Foreign Affairs. Global security consultant John Pike, who for years led the military analysis team at the Federation of American Scientists, has written that when these robotic ground legions are fully developed and deployed in only a decade or two, quote, no human army could withstand such an onslaught, unquote. A prospect that should unite US soldiers, Russian troops, Chinese squadrons, and Middle Eastern jihadi commandos in a human brotherhood and sisterhood of fear. For whatever our conflict may be, we are all of us still human beings. The gravest warnings of where accelerating corporate and state technology is rapidly leading, from global war zones to our brave new domestic society, come from inside the technological establishment itself. Dr. Sherry Turkle at MIT, Professor Stephen Hawking, billionaire Tesla Motors founder Elon Musk, brilliant software architect Bill Joy. 15 years ago, Bill Joy warned in his essay, Why the Future Doesn't Need Us, that 21st century biotechnology, robotics, AI, and nanotech might well merge into a new array of autonomous, synthetic, self-replicating entities that would rapidly displace the natural life forms of Earth, what we call God's creation. Unless humanity relinquished these technological research directions, on May 1st of last year, 2014, Stephen Hawking and 3 eminent colleagues warned in the London Independent, quote, the short-term impact of artificial intelligence, military and non-military. The short-term impact of artificial intelligence depends on who controls it. But they continue beyond the short term, quote, the impact depends on whether, in fact, it can be controlled at all. Elon Musk of SpaceX and Tesla Motors, hardly a religious fanatic or Luddite radical, has concisely described the accelerating rush into global artificial intelligence development, which is led by the military and the multinational corporate sector. He calls it simply summoning the demon. In this brave new century, as humanity faces a demonic counter-creation of robotic legions, synthetic organisms, and expanding artificial intelligence, the ultimate idols, rings of power, gods of metal and silicon, servants that may swiftly turn on their masters, at this moment in history, where, sisters and brothers, is the voice of the church, of the temple, of the mosque, and the synagogue? The preoccupied leaders of my own denomination, the Mennonite Peace Church, seem stubbornly unwilling to face these challenges, even as a basic resolution of concern. I can only pray that the events of 2015 prove me wrong on this point. At this conference, we cannot realistically challenge the drones without challenging the matrix from which they emerge, setting boundaries and limits on our vast technological hubris. Science proves what common sense knows, that something potentially beneficial turns toxic when taken to excess. We need not only prophetic voices against the current of this madness, declaring that we are God's children, not rival creators who seek to forge a matrix of synthetic organisms. No, we also need action, direct action, a national religious task force to organize greatly expanded, prophetic and risky direct action, a long-distance march like Gandhi and Chavez and King to end with mass, nonviolent, strategic obstruction at a key center of robotic, corporate, and military power, like the Salt March, Delano, or Selma. Finally, I want to share with you this. 1 year before he was murdered, an increasingly radicalized Dr. Martin Luther King told the nation, "When machines and computers, profits and property rights are considered more important than people, the giant triplets of racism, materialism, and militarism are incapable of being conquered. Shall we say that the odds are too great?" King continued. "Shall we say that the struggle is too hard? Or will there be another message of longing, of hope, of solidarity, whatever the cost? The choice is ours," concluded Dr. King, "and although we might prefer it otherwise, we must choose at this crucial moment of human history." Thank you.
Thank you so much, Peter. Gabor Rona is going to speak to us now. Is Gabor here? Yeah. Okay, very good. He is visiting professor of law at the Benjamin Cardozo School of Law at Yeshiva University. He has been with Human Rights First, has worked as a legal advisor in the legal division of the International Committee on the Red Cross, has a long and storied and distinguished career, and we're grateful that he's here with us this morning.
Thank you so much, and good morning, everybody. So in drone operator lingo, a strike, a hit, is known as a bug splat. Maybe you've heard that before. In Pakistan, people have taken to constructing humongous photographic images of children, large enough so that they can be seen from very high up in the air by a drone with a caption saying, "This is not a bug splat." Now that image is not about whether the war is just, but about whether the means of fighting it is just. And we can agree, as Representative Holt said yesterday, that the struggle against terrorism needs to be recast in the language not of war, but of crime. In fact, quite interestingly, the French, because of their language peculiarity, have the ability to say something quite different about the struggle against terrorism than we do. In French, it's called the lutte contre terrorisme, and lutte means struggle. Perhaps a much more apt representation of what we are dealing with and what we have to deal with than war. However, even if we do agree with Representative Holt that this needs to be recast, that's largely a matter of policy and not so much law. So I will talk now about law because that is the language of those that are in charge of the policy. And I suspect that you're not going to like a lot of what I'm going to say about the law. Killing is not illegal per se in war, in armed conflict. And it's also not illegal per se in some situations outside of armed conflict. For example, in self-defense, or when a police officer kills a fleeing felon. So, you might disagree with that as a matter of policy, as a matter of morality, but I'm talking about the law. I'm not supporting the law, I'm not defending the law, I'm telling you what the law is. And it's important to know it, as I said, because that is the language of the policymakers. Killing is not illegal per se in war. And this has several consequences to some of the things that we've already been discussing and hearing about since last night and today. Kill lists According to international law and domestic law, there is nothing per se unlawful about knowing the name of the person that is being killed in an armed conflict. Signature strikes. There is nothing per se unlawful about killing somebody on account of their conduct as opposed to their identity, of course, depending on what their conduct is. Collateral damage. There is nothing unlawful per se about civilian casualties in armed conflict. And it is important to understand the minutiae, the details of all of these separate and related facts of law in order to be able to advocate effectively, I believe, against the use of targeted killing. I want to spend the rest of my time talking about the two major international legal frameworks that apply to targeted killing. One is the law of armed conflict, and the other is human rights law. And the differences between the two on questions of targeting are significant. In an armed conflict, you can legally target enemy combatants, members of enemy armed forces, and even civilians who are directly participating in hostilities, but only while they are directly participating in hostilities. That is the law of armed conflict. It's a rather broad killing authority. Outside of armed conflict, it's human rights law that applies exclusively. And human rights law has a much narrower scope of permissibility to killing. It can't be said that you may not kill people outside of armed conflict. Human rights law provides that lethal force may only be used when necessary to protect against an imminent threat to life that cannot otherwise be ameliorated. So even outside of armed conflict, the law foresees and permits killing extrajudicially under some circumstances. But the difference between the law of armed conflict paradigm and the human rights law paradigm is extremely significant. And therefore, it is also extremely significant and critical to be able to distinguish between whether killing is being done in an armed conflict or outside of an armed conflict. And this is one very significant area in which the United States, in the extent to which it has, through its authorities, explained its practice and explained its policy, has left us very much in the dark. And it has left us in the dark, I suppose, quite intentionally. Because to either confuse or conflate or fail to distinguish between what is claimed to be armed conflict authority and what is claimed to be outside of the realm of armed conflict enables the United States to operate in a gray area. And it is important to those of us who are advocating against targeted killing, I think, to be able to specify and to demand of the policymakers to tell us precisely, are you or are you not using law of armed conflict authority for your targeted killing in Yemen? If you are, who are we at war against there? And if you're not, then tell us precisely why you believe that the people we are killing in Yemen represent an imminent threat to the life of Americans that cannot be ameliorated otherwise. And while we don't know a lot about facts on the ground, there have been quite a few studies that have attempted, and with some success, to determine that whether or not we are in an armed conflict situation in a particular place can be determined. And if we are in an armed conflict situation in a particular place, whether or not the individuals who have been targeted are or are not members of enemy armed forces, are or are not directly participating in hostilities at the moment of their death. And if it's outside of the realm of an armed conflict, there have been investigations that have quite clearly shown that a lot of the people who have been targeted may or may not have been, and in particular, many of them have not been representing an imminent threat to the life of Americans. And even if arguably they have been, that there were many circumstances in which those individuals readily could have been arrested rather than eliminated. These are the kinds of details that I think it is necessary for those of us who want to be advocating against targeted killing to be able to hone in on in order to have useful conversations with those in power. I recall when Jay Johnson, who is now the head of Homeland Security, he was chief legal counsel in the Pentagon before he took this job, and I had a conversation with him about drone strikes, and his major talking point that I think he was, most proud of was that, well, in the Defense Department, in the Pentagon, in our military operations, we always follow the law of war. He considered that to be a defense of the US government's practices. I consider it to be an admission of violation of the law. And the reason is simply that not everything that the military does happens in the context of armed conflict. There are specific rules to what constitutes an armed conflict under the law of war. And it is not because the US has declared war against either Al-Qaeda or terrorism more broadly. It is not because military means are being used. Rather, it's because there are either severe or intense or frequent hostilities between two armed entities that each have a command structure capable of applying the laws of armed conflict, whether they choose to do so or not. That's what constitutes an armed conflict. And if those criteria are not met, then you have no business, either proudly or otherwise, stating that you obey the laws of war. In those situations where the laws of war don't apply, then it is the less permissive rules of human rights law that limit who can be killed. In addition to this question of is it or is it not war, is it or is it not armed conflict, even within armed conflict, a serious dispute occurs about the propriety of targeted killing as to the specific targets. Is it or is it not a combatant? Is it or is it not a civilian directly participating in hostilities at the moment of their targeting? If you read a lot of newspaper accounts of targeted killing strikes, there are several words that you're bound to come up with rather regularly, like militant, like terrorist, like insurgent, like enemy, and my favorite one, bad guy. And you very rarely come up against the term combatant, but even when you do, it's used colloquially. There is very little in the journalism that we see in connection with targeted killings that even considers addressing whether or not the individual being targeted is in fact targetable. And as long as the general language of targeted killing continues to be focused on terms like militant, insurgent, terrorist, etc., it is creating an assumption and a false impression that anyone who may fall within those general and hard to define terms is conceivably targetable. And that's a flaw of journalism. But it's also a flaw of, I think, many of us who fail to distinguish the utility, who fail to apply or fail to know the law that is actually applicable to whether or not a killing is lawful under international rules. The question of civilian harm is another area in which the vocabulary, I think, fails us. We tend to hear and talk a lot about collateral damage and civilian harm. Civilian as opposed to what? Civilians as opposed to combatants. Well, as soon as you're talking about civilians as opposed to combatants, you're talking about armed conflict. And once again, whether or not the rules of war apply to a particular targeted killing scenario is rather questionable. So while it's very difficult to get away from the terminology of civilian deaths, again, it is important, I think, for those of us who are doing advocacy in this area to understand when we use the term civilian, we actually create a risk of conflating war and non-war. Because as soon as we use the term civilian, we are implying a contradistinction between those people and combatants. Outside of armed conflict, you don't have civilians and combatants. Outside of armed conflict, everyone is a civilian. And so the use of the term civilian, while I have to admit it's very difficult to get away from, is something that we have to be very careful about. Even within the realm of armed conflict, the concept of civilian casualties is most often referred to in connection with people who were not intended to be killed, but were nonetheless killed in connection with an attack against someone who was intended to be killed. That's the concept of collateral damage. And whether we like it or not, the law of war contemplates and accepts the notion of collateral damage with the caveat that it has to be proportional to the military advantage gained in an attack. Again, this is a law of war framework, and it has no business being used outside of armed conflict. Now, even within armed conflict, this frame, though, neglects one very significant category of people who are killed and shouldn't have been killed. When you talk about collateral damage, the reference is, as I said, to people who you didn't want to kill, but you perhaps knew were going to be killed in connection with an otherwise lawful attack, and that is lawful under the laws of armed conflict so long as the civilian harm is not disproportionate to the military advantage gained. But the one larger area of casualties that shouldn't have occurred that this formula neglects is the people who were intended to be targeted, but whose targeting was a violation of international law. So these newspaper accounts that talk about terrorists and militants and insurgents being killed, and the assumption that I think most people make when they read those terms is, well, those were legitimate. If, in fact, they were insurgents, terrorists, militants, then targeting them is legitimate. No. Targeting in an armed conflict is only legitimate against a member of the enemy armed forces or a civilian directly participating in hostilities at the moment of targeting. And I submit that the category of individuals wrongfully killed by targeted killing that consists of what we call pure collateral damage, in other words, individuals unfortunately but knowingly killed in connection with a lawful attack, is a much smaller category than the category of individuals intentionally targeted in violation of international law. So what I want to leave you with are essentially these three concepts. One, the importance of distinguishing between what is and isn't war in accordance with definitions and distinctions in international law, because when it's law of war targeting, then the lawful power to kill is much broader than when it isn't war. The difference between the application of law of armed conflict, which has a broad targeting authority, and on the other hand, human rights law, which has a much narrower targeting authority. The difference between what is and isn't war. Number two, the difference between what is and isn't a combatant. Do not accept terminology like militant, terrorist. Recognize and go forth with advocacy that hews to the concepts of international law, which narrowly define who may be targeted in an armed conflict as individuals who are members of enemy armed forces or civilians directly participating in hostilities. That's it. And finally, in connection with the concept of civilian casualties, I believe it's important to recognize and use in our advocacy the fact that it is not only women and children and old folks that constitute what we call collateral damage, but that there is also an even more significant number, I believe, of individuals who are wrongfully being targeted because they are falsely considered or falsely named to be targetable under the laws of war, even when they're not. Thank you.
Thank you, Professor Rona. Our next speaker will be Elizabeth Beavers. She is the Legislative Associate on Militarism and Civil Liberties with the Friends Committee on National Legislation, where she focuses on repealing the 2001 authorization for the use of military force, demilitarizing U.S. police forces, and closing the detention facility at Guantanamo Bay. Before coming to FCNL, Elizabeth worked in the field of immigration. Aside from obsessing over headlines and political minutia, Elizabeth enjoys traveling every chance she gets and working to overcome her Diet Coke addiction. Welcome.
Thank you all. Good morning.
Good morning.
I'm so pleased to be here with you. I am from the Friends Committee on National Legislation, a Quaker organization in Washington, D.C., if you're not familiar with us. It's so nice to be here with capital F friends and lowercase f friends and everyone who is interested in wrestling with the moral questions of drone warfare together. As that introduction pointed out, I work on several issues of national security, militarism, and civil liberties, and finding those intersections from a faith perspective. One thing that is central to everything I work on is what we call the AUMF. So I want to talk to you about the story of the 2001 authorization for the use of military force, the AUMF. I'm going to hone in on that really specifically. So I've got a few questions that we're going to answer here together. The first one is, what is the AUMF? Where did it come from? So immediately after the attacks of September 11th, I think we all remember there was this feeling in the air, this tension, this sort of human desire to retaliate, to answer militarily. And I should stop here, and I'm really glad I gave this talk at a high school, and I said, I think we all remember what that was like. And they were all like, we don't remember. We were like 2. So I'm pleased that I'm with people who also remember today. But yeah, so there was that sense in the air that we wanted to retaliate. And of course, militarism is the way we respond to threats, and that is what is baked into us, and that is our reaction. So here was a really difficult task. I think, as we all know, it is the constitutional mandate, not of the executive branch, but of the legislative branch, to choose when and where to go to war. This is because, as the founders foresaw in their documents, and we can read a lot of fascinating discussion from James Madison and others, that the executive branch is the one that is most prone to go to war. And that is why that check was put into the Constitution, to ensure that there wasn't the singular decision when and where to go to war, when to use lethal force, in the hands of one singular executive. That is why that decision was placed in the legislative branch. So it was the responsibility of Congress to declare war. Now, as we may know, we haven't declared war in quite a while. Not officially. What we've gotten into doing is Congress authorizes force. So here was a unique challenge. How do you authorize force in this situation? In those really confusing days after September 11th, there were these questions of, who are we targeting? Where are they? What does it mean to defeat them? So there was a lot of wrangling there among attorneys, among members of Congress, among the executive and others, saying, how exactly do we craft this specific authorization for force in the wake of what just happened? So what they came up with was 60 words. A single sentence. It's been called the most dangerous sentence in American history. I'll read it for you. That the president is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. Does that sound specific to you? So that was passed 3 days after September 11th by Congress. It was hasty, it was quick, there was an urgency. Does anybody know what the vote count was on that vote? That's right. One person voted against it. It was nearly unanimous, and that was Congresswoman Barbara Lee of California. And we love Barbara Lee. So I encourage for the high-tech among us, get on YouTube and check out her floor speech of the day that she decided to vote against it. Because it was a really moving floor speech. And one of the things that really struck me was she begged her fellow members of Congress, as we move forward, as we act, let us not become the evil we deplore. And I think that was really prescient, because that was September of 2001, and here we are together, 2015. That AUMF is still with us. So let's dive a little more deep. What exactly is the AUMF? We've just read the text. It has no geographic boundaries, no sunset clause, no defined targets, no identification of when this war would be over or when the mission would be accomplished. In addition to that enormous textual sort of blank check, there's been this phrase that has been interpreted into it. I'm sure you've heard it many times, associated forces. Whenever the administration talks about who it is that we're targeting, who it is we're fighting, there's this sort of laundry list of, well, Al-Qaeda, Taliban, this group, that group, and of course associated forces. What does that mean? We don't really know. There's never been a clear answer. Members of Congress have actually held hearings to try to get to the bottom of exactly what the administration means when they talk about targeting associated forces. We've gotten certain answers, such as, there is no official list per se of which organizations or individuals are considered to be associated forces. An individual who wasn't even born on September 11th could later in life be targeted by the AUMF because they associated himself with a group who at some points associates itself with Al-Qaeda. Senator Angus King of Maine, I think, had my favorite reaction to the idea of associated forces. He said to an administration official, "You keep using this term associated forces. That's not in the AUMF." And you said at one point, oh, it suits us very well. I assume it does suit you very well because you're reading it to cover everything and anything. And you guys have invented this term associated forces that is nowhere in this document. It is the justification for everything, and it renders the war powers of the Congress null and void. Is a really harsh line of questioning there. So I think that's correct. The AUMF has essentially turned the globe into a battlefield. It's very easy for the executive to bypass the legislature and decide to go to war, to use lethal force, to use military force against individuals and organizations. And this is a really novel concept. It wasn't an authorization of force against an established army or a clear-cut fighting force, something that Gabor went into a little more in depth with us. Or individuals can be targeted for their affiliations and their associations. So unfortunately, I should also add that this idea of associated forces has been validated by the court system, largely in the law of detention and what's been happening in Guantanamo and elsewhere. Basically, the AUMF is the legal justification for that indefinite detention that's taking place. The courts have essentially decided that if someone can be targeted, they can be detained. So when detainees challenge that through the writ of habeas corpus, the court has to decide, does the AUMF cover detention of this individual? And unfortunately, most of the time they found that it does. They have used this idea of associated forces to justify detention and included a broad, expansive idea of the AUMF. A DC Circuit judge recognized this problem last year and wrote in an opinion that it was 2013, not last year now. The troubling question in these detainee cases is whether the law of the circuit has stretched the meaning of the AUMF so far beyond the terms of these statutory authorizations that habeas corpus proceedings are functionally useless. It's amazing the breadth of the AUMF. So let's talk, why does it matter? What effect has it had to be this broad? Under the AUMF, the United States has engaged in military action in Afghanistan, Iraq, the Philippines, Ethiopia, Kenya, Yemen, Somalia, and many others. As we already discussed, the detention in Guantanamo Bay is justified under the AUMF. Senator Durbin said at one point, none of us who voted for the 2001 AUMF could have envisioned that we were about to give future presidents the authority to fight terrorism as far-flung as Yemen and Somalia. Although I would argue that one person did foresee that. And that's why she voted against it. A former State Department official aptly described the AUMF like a Christmas tree. We just keep hanging more and more and more on it. I like that visual. So how does this relate to what we're all here to discuss, drone strikes? I think you can kind of see where this is going. The AUMF is largely the legal foundation for the targeted killing program for drone strikes. Again, as we said, it's novel in that it authorizes the president to use lethal force, not against a nation state or a specified army, but non-state actors, organizations, and individuals. It essentially turns the globe into a battlefield. We cannot talk about drones without talking about the AUMF. Reportedly, administration officials, when they decide who it is that's going to be targeted by drone strike, their first question they ask is this person AUMF-able? And usually it seems the answer is yes. Wendy will help us explore this further in her presentation, but I do want to note that the president does, of course, also have inherent constitutional powers as commander-in-chief, and these include the ability to repel immediate threats to the United States. This is a key part of the drones debate as well. But the AUMF allows the president to rely on specific authorization from Congress to justify his actions, and it enhances the scope of those inherent commander-in-chief powers. So while there's a complicated relationship here, the AUMF, it's the foundation of everything. It changes the entire calculus. So what's next? What will become of the AUMF? Will it go on in perpetuity? It's clear at this point that for the AUMF and the resulting drones program to change in any way, there must be active affirmative change in the law. It will not fade out on its own because it is by design an endless war. Let me say that again. It is by design an endless war. President Obama has indicated a desire to change or to end the 2001 AUMF. In a speech at the National Defense University in May of 2013, he talked about fighting terrorism without keeping America on a perpetual war footing. He said, unless we discipline our thinking, our definitions, our actions, we may be drawn into more wars we don't need to fight or continue to grant presidents unbound powers more suited for traditional armed conflicts between nation states. He then expressed a desire to refine and ultimately repeal the AUMF's mandate. More recently, he's called Congress to right-size or to update the AUMF. However, so far the administration has not taken affirmative actions to move that conversation forward and to work towards actually amending or repealing the AUMF. So what has Congress done? I'll preface this by saying this is prior to the crisis that's happening right now in Iraq and Syria. We'll get to that in a second. But before that, members of Congress have attempted to force votes to sunset or repeal the AUMF. Barbara Lee, of course, introduces a bill every year to repeal it. For the past 2 years, Congressman Adam Schiff of California has introduced amendments to large military authorization bills that would sunset the AUMF. These amendments did fail, but the vote count is really astonishing. Between the two votes together, 210 members of Congress of the House of Representatives voted in favor of repealing the AUMF. That's enormous. It was a bipartisan vote. Now, elections have happened and swept a few of those affirmative votes out, but and they didn't vote at the same time, weirdly enough. But 210 total members of Congress voted to repeal the AUMF. It's enormous. The calculus is much different now, though. The midterm elections did sweep out a few of those members who voted for AUMF sunset, and the atrocities happening in Iraq and Syria with regard to the extremist group known as ISIS, ISIL, the Islamic State, Daesh, I don't know what else. Regardless of the name, this surge in violence prompted a new U.S. military campaign in the region, and this is really important. The president did not come to Congress before beginning this bombing campaign. He said he already had legal authority, and you can probably guess what it is. That's right, he cited the 2001 AUMF as justification for yet another military campaign. I think this is evidence that the AUMF will continue to be stretched and used for new things as long as it remains with us. So now, as you may have heard in the President's State of the Union address the other night, there is potential for a new AUMF. Many members of Congress, and now the President, are saying that there should be a new, more specific AUMF authorizing force against ISIS. This presents an important new opportunity to re-examine the 2001 AUMF. Let me tell you why. There could be a brand new AUMF, and it could serve as a new venue to address the old 2001 blank check AUMF. It could include a provision that repeals the 2001 AUMF or sunset in some way. It could include provisions that provide geographic boundaries, time limits, or more defined targets. This discussion is happening. It's happening right now. I'll leave you with an update on where this legislation is. At the very end of 2014, right before Congress went into their December recess, the Senate Foreign Relations Committee passed a new ISIS-specific AUMF. I encourage you again to go online, watch the video of the debate, because it is fascinating that after all this time, we are still having the same conversation. They went round and round in circles about how do we limit the president's authority, or if we should limit the president's authority. There were suggestions to provide geographic limitations or explicitly state that this new authorization would not target associated forces. Those amendments were not adopted. However, a provision was included that would sunset this new AUMF and the old 2001 AUMF after 3 years. So I say all this to tell you two things. One, this is very much a live debate. Right now, as we're sitting in this conference, White House and congressional leaders are debating and are thinking through the future of war authority. They are going to have to make some hard decisions, probably in the upcoming year. We have an amazing opportunity to be a part of that process and to influence that debate. The second thing is that after all this time, it's amazing to me that we are still fighting the same fights and having the same conversations. when SFRC, the Senate Foreign Relations Committee, couldn't agree to place boundaries on a new war or to ban the interpretation of associated forces, they're running the risk of making the exact same mistakes all over again with a new AUMF. There are moral questions at the heart of these issues. This community is uniquely positioned to provide a framework that bare law and policy by itself cannot address. I'm so honored to be a part of this conference and look forward to working together on the future of the AUMF. Thank you so much for having me.
Thank you so much, Elizabeth. Our final speaker this morning is Wendy Patten, a senior policy analyst at the Open Society Foundations in Washington. Wendy works there to develop and implement advocacy strategies on immigration, human rights, and counterterrorism issues. She's worked on many issues as a legal aid lawyer, a government official, and an advocate for prominent NGOs. We welcome Wendy Patten.
Good morning, everyone.
Good morning.
I want to thank the Peace Action Education Fund for inviting me to be here with you today, and also the Princeton Theological Seminary for hosting this conference. So I'm going to follow up on the discussion we've been having with Gabor and with Elizabeth about legal issues around drones, the international legal framework, and then Elizabeth was beginning a long discussion about domestic law focusing on the AUMF. What I want to do is talk about the way in which the administration has been interpreting those legal authorities with a particular focus on some presidential policy guidance. And I want to talk about what we know about that guidance. I'll walk you through what it says, and then what are some of the questions that are still unanswered about what are some of these legal interpretations and the way that they're being applied. So let me start off with the presidential policy guidance. This is guidance that was announced in May of 2013 when the president gave an important national security speech at the National Defense University. He talked about other issues like re-engaging in the effort to close Guantanamo. He talked about, relevant to what Elizabeth was just saying, the notion of the war against al-Qaeda, and he said that this war, like all wars, must end. But he also talked about drone strikes and how drones are being used and some of the ways in which the administration has tried to put a framework on the way it's using drones and some constraints on it. So let me tell you a little bit about that guidance. It is called, its full title I'll give you so that if you want to look it up, what we have is a 2-page summary of the guidance. The guidance itself is a classified document, but there's a 2-page fact sheet. And the full title of that fact sheet is U.S. Policy Standards and Procedures for the Use of Force in Counterterrorism Operations Outside the U.S. and Areas of Active Hostilities. The president in his speech talked about the issue this way. He said, America's legitimate claim of self-defense cannot be the end of the discussion. To say that a military tactic is legal or even effective is not to say it is wise or moral in every instance. For the same human progress that gives us the technology to strike half a world away also demands the discipline to constrain that power or risk abusing it. And that's why over the last 4 years, my administration has worked vigorously to establish a framework that governs our use of force against terrorists, insisting upon clear guidelines, oversight, and accountability that is now codified in this Presidential Policy Guidance, or PPG. So let's take a look at a closer look at the PPG, or at this 2-page summary that we have of it. What I'm going to do is go over a few of the key points and then talk about some of the questions that remain. So first of all, as you can tell by the title, which talked about the use of force in counterterrorism operations outside the U.S. and areas of active hostility, by its terms, it applies only to actions outside areas of active hostilities. So that's relevant to what Gabor was describing in terms of the laws of war. When we're talking about a zone of active combat, this guidance doesn't apply. In that setting, drones can be used according to the laws of war like other weapons. They have to comply with the laws of war and some of the principles that Gabor articulated, like the principle of distinction, distinguishing civilians from combatants, and proportionality. But they're used according to the laws of war. This guidance is meant to apply, again, outside of areas of active hostilities. So we'll think some more about that. What we see here is that the concern of many human rights groups is with the very use that's covered by the PPG, the use of armed drones away from traditional battlefields, where states targets individuals who are believed to pose an imminent threat from long distance and in secret, and thinking about how this new drone technology may make this particular use of lethal force more possible. Now, the PPG states right up front that the US government has a preference for capture. So it's US policy not to use lethal force when it's feasible to capture a terrorist suspect. It also sets out some standards for the use of lethal force, beginning with two overarching principles. One, that this lethal force is not to be used as punishment or as a substitute for prosecution. And second, lethal force, drone strikes, are only to be used to prevent or stop attacks against US persons, and even then only when no other reasonable alternative is available to address the threat effectively. So those are the two overarching principles that are set forth in this PPG. Then it articulates that lethal force can be used outside areas of active hostility only when the following criteria are met. And here they are. First, there's a legal basis for using lethal force. Second, lethal force can be used only against a target that poses a continuing imminent threat to US persons. Third, then there are some more specific criteria that have to be met. Near certainty that a terrorist target is present. Near certainty that non-combatants will not be injured or killed. That capture is not feasible at the time of operation. That the government or country in question cannot or will not address the threat effectively. And that there's no other reasonable alternative to address the threat effectively. The guidance also emphasizes that the US will respect international law on the use of force in foreign territories, and there they're referring to the question of state sovereignty, that they will respect the sovereignty of the state on whose territory they are acting. And then finally, they note that the guidance notes that if the US is targeting a US person, so that is typically used to mean a US citizen or a lawful permanent resident. In that case, they will do additional legal analysis to ensure compliance with the Constitution and the laws of the United States. Okay? So that's what's set out in this two-page summary of the Presidential Policy Guidance, or PPG. So what are some of the things we still don't know about it, or what are some of the questions that we have about its meaning? Well, we've talked about how it applies to areas outside of active hostilities. So where then does the PPG apply? Which places in the world are considered areas of active hostilities and which are not? Elizabeth talked a little bit about that when she talked about where the AUMF might apply or not. How does that intersect with how they think about active hostilities in terms of whether this guidance covers the use of drone strikes? Well, probably not Afghanistan. Certainly not through till the end of last year, where we were involved in combat in Afghanistan. Has that changed with the end of combat operations there? Well, some recent reporting suggests that even with the formal end of US combat operations in December, Afghanistan continues to be considered an area of active hostilities, at least for much of this year. And that seems to be both about the nature of what's happening on the ground there and also the nature of the continued presence of US forces there through this year. So this PPG probably doesn't apply in Afghanistan. And so again, what does that mean? It means they're following the laws of war in terms of engagement, not these specific rules. What about Pakistan? Well, it's hard to say. But we can assume that it probably follows a similar course and will be treated the same way as Afghanistan, at least the areas of Pakistan that are near the Afghan border, because those have tended to be seen as part of the Afghan theater of war. And there's also a force protection rationale, that it is, there's a need to protect US forces fighting in Afghanistan from cross-border attacks. So, and again, there's some recent reporting that suggests that these questions are likely to go in parallel. But we don't know for sure because the use of drones in Pakistan is not something that's publicly acknowledged. What about Iraq and Syria, right? And the current fighting there against ISIL. Does the PPG apply to drone strikes there? No, it does not. That is because it's clearly an area of active hostilities, and the White House affirmed in the fall that because it's not outside of active hostilities, but rather it is active hostilities, that the PPG would not apply there. What about Yemen or Somalia? Well, we don't know for sure. The administration has not stated clearly whether it's following the rules of the PPG there, or rather it's following the laws of war that govern drone strikes. And in Yemen, as with Pakistan, the US government doesn't acknowledge or discuss the use of drones. So it leaves us with some questions about, we've got this set of rules that is meant to constrain the use of drones away from recognized battlefields, away from where, as Gabor described, the laws of war apply to the use of lethal force. But we don't exactly know where in the world is it being applied. Another question we don't know is the meaning of some of the key terms that I was describing that are used in the PPG. One of them, and one that you'll hear more about today, but I want to flag for you now, is imminence. Gabor talked about how under human rights law, away from an armed conflict, states can use lethal force to repel an imminent attack if they don't have another alternative to address or remedy that threat. Well, the PPG uses the term continuing imminent threat. What does that mean? The term itself is not explained in the PPG, in the two-page summary. It may be explained in the full classified document, but it's not explained in the two-page summary that we have. So that raises some important questions about how expansive is this interpretation of the term imminence under international law. It seems, by using the term continuing imminent threat, to be referring to an unspecified adverse action at some undefined point in the future. But again, we don't know what this term means. And so how can we think about whether that term is consistent with the way we understand or other interpretations of the term imminence under international law? Another thing that I mentioned was this question of feasibility of capture and the preference for capture, and to use lethal force only when capture is not feasible. Well, that raises questions about how is the feasibility of capture defined? And how is it determined? We don't know. Another question is the criteria for being determined to be a lawful target. One criterion that we've just discussed is continuing imminent threat, and we've talked about what that means in the administration's interpretation. But how else is that determination made that a specific person can lawfully be targeted, can lawfully be killed by a drone? The PPG, the two-page summary, says that there must be a legal basis for using lethal force, and it gives the example of a senior operational leader of a terrorist group or part of the forces of such a group. But again, how would they arrive at that conclusion with respect to a specific individual? These are questions that we don't know. And then even if they determine somebody may be a lawful target, how then do they reach the decision to go ahead and target them? How do they apply the criteria that is set forth in this document so that we can understand how someone is actually made the subject of a targeting decision? Another thing that we don't have is the number and identities of those who've been killed in drone strikes. We only know a few. One of the examples that the president actually spoke about in his speech at the National Defense University in May of 2013 was the strike against al-Awlaki, a US citizen in Yemen. And he lists that al-Awlaki and I believe 3 other people were killed in that strike. That information was declassified and spoken about by the president. But we don't have a full understanding of the numbers and the identities of those who are killed, which is important in so many ways, both for knowing what is happening, for being able to assess the policy, and assess some of the questions that we've been talking about today. And then, this is an important point. Even if we could answer all of our questions about this guidance satisfactorily. If we had more information and we could say, you know what, that is an appropriately constrained policy, or we think mostly they've tried to put some constraints on it that make sense. Another critical question is, how do we know if it's actually being followed in practice? You can have the right policy, but you have to follow it in practice. And of course, we don't have information about whether the standards they've set forth for themselves as constraints are actually being followed. And so much of that has to do with the amount of secrecy that surrounds the use of drones. So that is the PPG. I do want to take a minute to just note another way that we've learned some information about the US's legal interpretations of its authority to use drones, and that is from litigation. That will be discussed in more detail this afternoon, but I do want to note that that's another way. One way has been the information that the president has put forth in his speech and in this summary of this classified guidance. But another way, a source of information about these issues has been litigation. And it's a potential way of learning more about US policy and practice. And the primary example here is the lawsuit around the Al-Awlaki case. And in that case, both the New York Times and the ACLU brought suit for disclosure of the government's legal opinion, which was the basis of the strike against Al-Awlaki, who, as I mentioned, is a US citizen. The Federal Court of Appeal for the Second Circuit ordered the release of a redacted version last year. And so the legal opinion was actually made public by the government in response to that decision. As you'll hear more about, this is about the targeting of a US citizen only. So while it's really important that we know that and that information was released, it's obviously much narrower than it's much narrower a lens and much narrower than what's happening because the vast majority of people who are being targeted are not US citizens. But still, I just wanted to note that that is another way we've learned something, and this legal opinion is out there and is something that you can read that gives us some insights into how they're grappling with these bodies of law that we've been discussing today, the law of war, the international law of self-defense, human rights law, and then domestic law that is related to these concepts, the AUMF, the authorization to use military force, and then other principles of constitutional law that would apply in the case of a US person. So I want to turn now to talking a little bit about this question of transparency, what we don't know and what we need to know and why. And in particular, I want to focus on post-strike assessments and redress for harm. It's really important to place a focus on efforts to have less secrecy and more transparency when it comes to drone strikes. Doing more to assess strikes after they happen and to provide redress where it's warranted is not only a critical part of government accountability and a commitment to the rule of law, but it's also critically important in human rights and moral terms. If a strike caused harm to a civilian in armed conflict, or if the government unlawfully targeted someone outside of an armed conflict, that's really important to know. And doing an assessment gives the government an opportunity to try to make that right, or to at least do what it can to make amends. Now, even if the government may be resistant to making public some aspects of the policy, it should be willing to conduct much more thorough and meaningful post-strike assessments. And what's critical there is that they be more independent than they've been. They obviously shouldn't be done by the same people who were involved in the strike. And then to provide for redress. This is not unprecedented. The US military offers compensation in the form of what are either called salacia or condolence payments, in armed conflicts for civilian harm. And the military has done that in the Iraq War and in Afghanistan. So this is an idea that could be extended, potentially, to drone strikes. Even the CIA Director John Brennan, during his confirmation hearings in 2013, said this about strikes that happen outside of declared war zones. He said, "Where possible, we also work with local governments to gather facts and, if appropriate, provide condolence payments to families of those killed." Now, the challenge we face in talking about this issue, of course, is that drone strikes in Pakistan and Yemen are secret and not publicly acknowledged by the government. But it's something that they could do, and it's not unprecedented. And this is the beginning of trying to understand and assess what is the policy and is it being followed. And if they arrive at conclusions that either mistakes were made or that harm was caused, can they take steps to address that? So I just want to finish with this thought. When we think about the legal questions that we've been discussing today and how it applies to drone strikes, it's critically important to achieve greater transparency and accountability, both as a check on the use of this power and to ensure redress for civilian harm and unlawful targets. Opening up government action to scrutiny can help ensure drone strike policy is sufficiently constrained, that it complies in practice with domestic and international law, and it can help make the use of lethal force more accountable, both in terms of providing redress where it's warranted and in promoting public scrutiny. So how can we achieve greater transparency? Many human rights groups have been calling for that, and it has been a challenge. Well, I want to indicate one small ray of hope, and that has been some limited disclosure thus far of drone strikes conducted by the military in Somalia. In December, the Department of Defense stated that it had carried out a drone strike. It said when. It said it was against a senior operational leader of Al-Shabaab. They gave his name, and they explained his role within Al-Shabaab, and they said the region in the country where the strike had taken place. They had the Pentagon press secretary describe this strike, and then they put out a small press release. Now, this is a very small step, just a dipping of the toe in the water, but it is a start. And hopefully it's something we can build on in pushing for the government to disclose more, at least after the fact, about these strikes. There's another important potential change that we could try to make, and that is to transfer the authority to conduct strikes from the CIA to DoD, so that the authority resides wholly with the Department of Defense, and that the CIA is no longer involved in conducting strikes. This has been discussed for well over a year. But what first seemed to have some traction and an idea that might move now seems rather stalled. So, you know, putting DoD solely in charge won't solve the problem entirely. There's still going to need to be a push for transparency and accountability. But there's fairly widespread agreement that DoD is where the use of lethal force belongs in the first instance. And it's likely to be more transparent than if the use of drone strikes remains in the CIA. Another thing to consider is that we are approaching the end of the Obama administration. There are 2 years left. And as the president looks to his legacy and the authorities and precedents that he's going to leave behind to his successor, the president will likely want to ensure that the use of armed drones is appropriately constrained. And indeed, he acknowledged the importance of such constraints and of greater transparency and oversight in his speech in 2013. So now, at the end of the administration, presents an opportunity to advocate for achieving the goals that he laid out in that speech and to see that they're met by the end of his term. So I just want to close with two important thoughts for us to think about as we look to the future. One is that it's important to consider the precedent that the US is setting in a world in which drone technology is proliferating. How will other governments use this technology against those they identify as threats? And how do we ensure this power is sufficiently constrained and transparent so that there can be accountability for the use of lethal force by states? That's what makes this discussion so important. And secondly, it's also really important to understand whether this drone technology and other kinds of technology that will surely follow will lower the barrier to the use of lethal force against individuals, and what that means for a future where human rights, democracy, and peace can thrive. Thank you. We've had a couple of different UN special rapporteurs who have looked at the question, who have tried to understand and identify both what international law says about the appropriate scope, where some of the key questions are, and to raise questions about the practice. They've issued reports, and I just don't know whether there is any planned follow-up or moment at which there's this, I don't think, yeah, Gabor is shaking his head. So that has happened, so I think we're in this place where we have to say, okay, so what's the next step? Will they follow up by trying to do some more research in the field about what's happening with drones and put that on the table, or is this a moment where also advocates will be coming back to these UN special rapporteurs or UN bodies to ask them to look into it further?
Wendy just mentioned the special rapporteurs. It's the UN Human Rights Council has this kind of whole universe of what's called special procedures. They're individuals, volunteers that are appointed to look into specific human rights problems, either by theme or by location. So there's a special rapporteur on extrajudicial killing. There's a special rapporteur on counterterrorism. These mechanisms not only have the ability to issue reports based on their research and findings, they also have the ability and in fact the responsibility to take on individual complaints and then to question the states whose responsibility is being alleged for violations of either human rights law or the law of armed conflict about these specific allegations, receive responses from those states, and then to include those exchanges and that information in their annual reports to both the Human Rights Council and to the General Assembly. So I think this individual complaint aspect of the powers and the mandate of the special rapporteurs could be put to better use. And that is a potential source of, a potential area of advocacy to be explored, I think, by opponents of targeted killing. More particularly, though, I do expect that the special rapporteurs on these areas, will be continuing to focus on the issue of targeted killing, if not drones in particular. But I'm not aware of any specific reports that are pending or coming out from them. As far as the General Assembly's annual exercise is concerned, I have to say I'm not too impressed by that. I don't think it's particularly useful or a ground for potential activism on our part to go to the General Assembly. The General Assembly will continue to say what it does against targeted killing and drones, but the real power within the UN itself is going to be in the Security Council, not the General Assembly on these matters. As to the question of should we define terrorists and how does the concept or the linguistics of terrorism play into issues about targeted killing, as I'm sure many of you know, there is still no internationally legal accepted definition of the term terrorism. I don't think that's an accident. I think states very much like to maintain uncertainty and vagueness. It gives them a certain room to maneuver with which they can take advantage of, and perhaps for that reason, I think it's not either necessary or useful for those of us that are engaged in anti-targeted killing work to focus on terrorism. More particularly, the question of whether or not somebody is legally targetable under existing interpretations of international law, be it in an armed conflict framework or outside of an armed conflict framework, does not turn on whether or somebody is or is not a person who engages in violent acts against civilians for the purpose of affecting governmental action, which is one of the more generally accepted, if not definitions, concepts of what terrorism is. I think since there isn't necessarily an overlap, let alone an identity, between targetable and terrorist, I think it probably is not useful and maybe even a mistake to use the concept of terrorism as a defining factor in connection with who may or may not be targetable. You could be a terrorist in the view of everyone in this room, perhaps, but still not be targetable either under the laws of war or laws of human rights.
I would just second that. When I was listening to your question, I was thinking exactly what Gabor just said, which is that label doesn't answer the question under international law as to whether a person is targetable. It turns on the kinds of things we've been discussing this morning that have to do with, a combatant in an armed conflict or the kind of imminent threat that is posed that we discussed. And that imminent threat analysis is intended to be a very narrow and exceptional circumstance. But I do think that you're quite right that when you sort of read stories about this, and as Gabor noted, you talked about the language that is often used to describe targets, you see that word. And I think it does play into the larger narrative of how we are addressing terrorist threats. And I think a number of us who have worked together on these issues had been hoping that with the end of combat operations in Afghanistan, it might be a moment, if not to fully move away from the war framework, although of course there was hope for that, then we might be able to move away from war-centric approaches to counterterrorism, that war might move from the front to the back of that strategy. And so I do think there is a place for policymakers and concerned citizens to be talking about what are approaches to dealing with counterterrorism that go beyond just talking about it in terms of war, because so often this debate has been framed as, war versus crime and which is the appropriate response, and just helping us to understand that the government has a range of different kinds of tools that include everything from criminal prosecution to disrupting terrorist financing and diplomacy and development, and a whole range of things that it can do. And it's not just simply the case that war responses need to be used for every terrorist threat. So I think it's there in the narrative, but I agree with Gabor that in terms of understanding where drone strikes can be used, that term doesn't really have relevance to the lawfulness of a drone strike.
I think that that is such an important point, is especially from us attorneys up here, is to think about these are people, and these are feelings, and these are lives that are impacted by what we discuss here and the policies that we put forward and the actions of the U.S. government and other governments. I think that as emotions are so raw and as these tragedies continue to happen, I actually just wrote a piece the other day in Roll Call, if you want to look it up, that I was wrestling with this myself, because as videos of beheadings come out and as we watch really awful things happen in real time, I work for a Quaker organization, and I have to come forward and say, don't retaliate militarily, and that's a radical and a terrifying thing to say sometimes. What I think is useful is to step back and look in the historical context, even the immediate historical context, and think about the last 13, 14 years. What have we accomplished by resorting to the militaristic response? What have we accomplished by resorting to the global war, endless war paradigm? Have we defeated terror? And clearly we have not. Have we made our own lives easier? Have we made the lives easier of those who are suffering from acts of extremism? Clearly we have not, and in many ways, whether it's recruiting that happens because of our actions in Guantanamo and through drone strikes, whether it's exacerbating anti-American sentiment, whether it's assisting in radicalization, many of our actions have actually exacerbated that threat of terror. So my question is not, why shouldn't we react militarily? It's, show me a situation in which that has accomplished our ends. And taking an opportunity to turn a page and try something else is what we advocate for. That was the first question.
Yeah, thank you for your question. I think on the second one, you've just pointed out, I think, some of the challenges of the moment that include not only these recent events, but it's worth remembering that when the president gave his speech about this in May of 2013, it was really before the advent of ISIS in the way that they are now. And so I think both of those things create a challenge to an environment where voices are trying to urge changes to these policies and to thinking a bit differently. That only makes the challenge harder, of course, but not one to shy away from. On your first point, you were talking about the way that governments relate to each other around drone strikes, and I just want to say a few words about that. I had mentioned that in this PPG, the US government talks about the importance of respecting international legal principles around national sovereignty. So that usually takes shape in one of two ways. A government that wants to use lethal force on another government's territory can get its consent, right? So that's one thing. So one question is the government getting the consent of places like Pakistan and Yemen when it uses drone strikes? And a challenge to that, again, is secrecy. So while the recently passed president of Yemen was talking a bit more publicly about his cooperation with the United States, in Pakistan, this isn't something that we know. We don't know whether there is an agreement or not because it's not discussed publicly. With respect to, then there's another way, which is if the government in question is either unable or unwilling to take the steps to mitigate the threat, then it may also be permissible for another government to use lethal force. But that, again, is meant to be a very narrow, exceptional circumstance. So what that does set up is a situation where the governments can be talking to each other and working together behind the scenes. But publicly, what they may be saying could be quite different. They could be saying nothing, or they could be expressing concerns about incursions on their sovereignty. And so it's a challenge for citizens, I think, in both places to understand what the dynamic is and to know how to advocate for, to know how to speak to both the use of drones and to these questions about the rule of law that undergird it. I don't know if you want to add to that, Gabor.
Yeah, one quick observation. Again, on the first point. Yes, consent, but consent for what? Consent to kill whom? There have been some indications. Yemen, I think, is a good example. The U.S. reaches a devil's bargain with the leadership there, essentially Yemen saying, okay, we will let you whack the guys you want to whack, but you got to whack some of the guys that we want whacked as well. And that's all under the rubric of consent, but it is still an abject violation of international law for the U.S. to be engaged in killing people who were perhaps involved in an insurgency against a local government, but who have done nothing to threaten or are not involved in any conflict with the United States.
Whenever I attend any sort of discussion at a think tank or similar organization in Washington that's about drone strikes or similar issues, I'm always struck by the very dichotomy that you're posing, which is there can be a panel of lawyers that walk us through all of the legal questions in their great detail. And then there can be a panel of policy folks who raise some of the kinds of questions that we've been talking about today in the broader sense. Is it wise? Is it right? Does it make sense? Does this actually advance objectives in the long term for a more peaceable and stable world? And I always find those panels incredibly interesting and insightful because they really put it in context. They say, okay, we can figure out all these legal questions about whether it's okay, but what are we trying to accomplish? And does this make sense as part of an effective counterterrorism strategy? So I do think that you're right, that part of the challenge is situating this debate in a larger question of how the United States and other countries are dealing with a range of threats in the world, and understanding that military responses are by no means the only ones and meant to be reserved for the most exceptional circumstances when no other options can effectively mitigate that kind of a threat to the United States. One thing that you might find interesting to look at is the administration's own strategy for dealing with terrorism, which I believe dates from 2011, but I'll check that for you. But it's something you can find on the White House website. And it's a document that often gets produced by the White House every few years. But I think it tries to begin to lay out that full range of tools that the government has. The question is, how do we shift the public narrative, particularly at this challenging moment with the concerns about ISIL, with questions about what will happen in Afghanistan, with some of the recent attacks that have happened. But I do think that that question, where we're going to need strong national security voices who can speak to other ways that aren't about just using lethal force, as well as a whole range of types of, as you said, faith voices and other voices who can help, shape that debate.
Okay.
Yeah.
I just want to address that really quickly because I personally sort of wrestle with that as well because I come from the legal background, but I am working with a Quaker lobbying organization. So I liked what Gabor said about understanding law. That is the language of the policymakers. And so if we're going to be strategic advocates, if we're going to be faith advocates or peace advocates or whatever it is that we consider ourselves to be, any individuals in this room, if we're going to provide a value add to Congress, to the administration, and we're going to help move the conversation along, if we understand the parameters under which the conversation is taking place, we can be more effective in moving it along. It's not effective for me to walk in and say, we're Quakers, please don't go to war, and walk out. If I can, they're not surprised by that. It's not a, spoiler alert that Quakers are here to advocate against war, but if we can go in and we can understand the conversation that's taking place and where those parameters are and help understand that what is the moral end that we're getting to and what mechanisms are in place to help us get there, I think it makes us stronger. I just would only comment and say I completely agree. I saw a lot of narrative in the news surrounding the release of the Senate Intelligence Committee's torture report, something like, well, if we're so angry about torture, what about drone strikes? And of course we say, yes, we're angry about that as well, and we need the transparency for that as well. I was really struck by some of the lead into the release of that report, all these sort of warnings, even from Secretary Kerry, that this is going to incite anger and violence around the world if we put this report out, and the easy answer to that is, well, it's the torture that brings about that response and not the admission that the torture happened, and the transparency of that. And so I think there's an exact logical line to make there that bringing about more transparency and accountability to the drones program most likely would only enhance the anger that we feel of what's being done on our behalf, and exacerbate the threat worldwide, and that hopefully kind of get the movement going to find change or abolition or wherever it is that we come from. So I agree with that point.
One issue that comes up about advocacy in connection with torture is, well, should we be arguing that torture doesn't work? It doesn't help. There's a dark side to going down that road because it's very difficult to actually determine for sure that it doesn't work depending on what somebody's definition of work is. And if you enter into that conversation, then you're almost ipso facto conceding the possibility that, well, if it works, then it's okay to do torture, which is somewhere where I think we don't want to go. I don't think that similar consideration occurs in connection with the use of targeted killing. I think in connection with targeted killing, the question of efficacy and whether or not we are creating more terrorists than we are getting rid of is a very valid point of advocacy. It may be a correct point of advocacy in connection with torture as well, but with torture I think it's a more dangerous road. I've worked in this realm of the law of armed conflict in both Europe and in the United States, and those comments remind me of something that I think is rather important. It's not just an issue about empathy generally, but I think there are also some significant differences between the American as opposed to some other countries' perspectives on these issues. Taking the law of war and war itself as a paradigm, Europeans have a living memory of the effects of war on civilian populations. There are still people old enough to remember that, or at the very least to have caused to some degree those considerations to be inculcated into the way their governments and their militaries operate, to some extent. The United States doesn't have wars on its soil. All of our wars take place elsewhere. And over the course of time, from the time that I worked in Europe on these law of armed conflict issues and then coming into the United States and particularly dealing with the militaries and the military establishments in Europe as distinct from those of the United States, I've come to believe that there are very different perspectives about the application of the law of war in America as opposed to Europe, and particularly based on the different experiences of those opposite sides of the Atlantic. In the United States, within the military, the perspective on the law of armed conflict is more motivated by force protection than civilian protection. I'm not saying the opposite is true in Europe, but at least in my experience with dealing with the military establishments of European countries, there is a greater understanding of the balance between force protection and civilian protection than is the case, in my impression, in the US military. And I think it has to do, it is a consequence of the very different experience that our wars don't take place on our soil, and they don't affect our civilians. They're always affecting somebody else's. And I think that's a significant difference.
I just thought of one comment on that. I want to bring it back home to drones, because I think exactly what Gabor is talking about goes exactly into the conversation that we're going to flesh out together later in this conference, which is that having drones is a specific issue in my portfolio. We do get asked sometimes, like, well, why drones? Why are we specifying that technology? And it's for this exact reason, that it takes that out of sight, out of mind, and draws it even further out of the American experience, and that war is something that happens to other people in other places, and we don't have to think about it, and we don't have to see it. And these strikes make that happen. It's more readily available. There are less people involved. It draws it away from the human experience in a way that doesn't make us as accountable and doesn't give us that visceral reaction when lethal force takes place. So it's the dehumanizing element that continues to sort of bring it out of our consciousness that we have a particular concern about.